the Supreme Court has decided since 9/11, the Holder, Eric Holder, the Attorney General, and the Humanitarian Law Project case, in which the court, Chief Justice Roberts writing the opinion, upheld the constitutionality of the statute, the law that made it a crime to give, quote, material support to designated terrorist organizations. And Congress defined material support to include expert advice and assistance, i.e. speech. And the court said that's valid for the reasons that the court gave, which included that giving a terrorist organization advice about how to deal nicely with their targets and their enemies, how to go to the United Nations, and so it would free up resources within the terrorist organization that it would otherwise have to spend on that. If somebody outside is helping them, then they can devote more of their resources to terrorism. No real evidence that that happens, but that the court bought the government's argument to that effect. And the court said that the resources are fungible. Expert advice and assistance is fungible with other kinds of resources, with money, with services, with employees, and so the terrorist organizations. And the court said that allowing assistance to terrorist organizations gives them legitimacy that they wouldn't otherwise have. So for those reasons, it was reasonable for Congress to make criminal giving advice and assistance to terrorist organizations. It's on the paper yesterday. One of the main terrorist organization that was involved in the Holder case was the Kurdish Workers' Party, or whatever it is, that represents the Kurdish minority in eastern Turkey. And they're the ones that the American organization wanted to help make their case to the UN and so on. Well, now our ally, I read in the paper yesterday, our ally Turkey, the Prime Minister, Erdogan, is trying to set up negotiations with the Kurdistan Workers' Party so that they can work out their differences. Well, I guess we can't encourage that. We can't provide any assistance to work it out. Well, here's how you ought to deal with Turkey, and you ought to, that would be a crime. It really doesn't. It's an unfortunate situation, I think, that the court allowed to happen, and unnecessarily so. To what extent do the needs of national security require limiting the time, place, and manner of speech? Well, we see that in the things like the way the protesters at political conventions were treated in the last few election cycles and will be for the foreseeable future. The governments of the cities where the protests take place, conventions take place, and the protesters gather, the cities will impose time, place, and manner restrictions in ways that ensure that the protesters will be neither seen nor heard by the people that they're targeting, the people in the convention hall. They'll be in a place remote from the convention center. They will not be allowed to parade in front of it. And so you have a right to be in the city, same city as the convention, but not to have your protest heard. And then there was the case about the protection of the vice president and the new federal law, or the amended federal law, that treats as a restricted building, any place where the Secret Service happens to be guarding somebody, the president, vice president. Many other officials get Secret Service protection. Well, if they happen to be there, that limits the ability to protest in or near that building. Under Clark, I suppose, those kinds of restrictions pass First Amendment muster. 4, prior restraints, WikiLeaks, and whistleblowers. The only cases we consider here are ones that have to be very familiar to you now, near, and the Pentagon Papers case. The questions: when can government order the press not to publish certain information? Well, the answer to that is the Pentagon Papers test, the one that Justice Stewart mentioned during the argument and then put in his opinion. That is, that the burden on government to overcome the presumption against prior restraints is that the government must prove that publication of the information will cause a grave, immediate, irreparable harm to the national security. And I should add, if the doctrine is not limited to national security cases and has been applied to at least one other case that I know of involving constitutional rights, but not national security. So it's to some tremendously important government interest that the harm has to occur. When, if ever, does the First Amendment allow government censorship of information in advance of publication? That's the same question. Another way of saying the same thing. Censorship in advance is prior restraint. Subsequent punishment, you do something that violates a criminal law and you are sentenced to jail for doing that, that's subsequent punishment, not prior restraint. Prior restraint where the government says, look, you've got this information in your hands and we're not going to let you publish it. That's prior restraint. Can WikiLeaks be successfully prosecuted for violation of the Espionage Act? Well, we don't know yet. Julian Assange is still in London and has not been indicted. Bradley Manning has been charged in military court-martial with, among other things, a violation of the Espionage Act. And last week he pleaded guilty to, I think, 10 counts in which he admitted that he was the guy. You don't have to say he allegedly did anything anymore. He was the guy who leaked the State Department cables and the other military communications to WikiLeaks. But the government, despite the plea of guilty to those 10 charges, they're going to prosecute him for violation of the Espionage Act and some remaining charges that I'm not familiar with. Julia?
How is that espionage?
Well, because the Espionage Act, it doesn't say spying is a crime. What it says is the disclosure of certain kinds of national security information to someone who is not authorized to have it violates the Espionage Act. WikiLeaks certainly is not authorized to have this classified information or the State Department cables. Well, the question whether WikiLeaks can be successfully prosecuted for it. The most analogous case was Pentagon Papers, where the government chose not to prosecute the New York Times, and no publisher of information has ever been prosecuted for violation of the Espionage Act. All of the prosecutions, and there haven't been that many, are of the government employees who disclosed the national security information of the Bradley Manning types in the world. And the government, of course, prosecuted unsuccessfully Daniel Ellsberg, the leaker of the Pentagon Papers. They chose not to prosecute the Times. So in the WikiLeaks situation, if Assange and or WikiLeaks is prosecuted, one of the questions will be, are they like the New York Times, a publisher? Or the government likes to bring conspiracy charges. Or did they conspire with Bradley Manning to violate the Espionage Act? And certainly if they paid Manning, they'd be a conspirator. If they gave him software assistance, helped him out, facilitated his leaks and so on, then they might be conspirators. But if they simply, like the New York Times and Pentagon Papers, got the leaks dumped in their lap and chose to publish them, then they're like the New York Times. And I believe that under a proper interpretation of the Espionage Act, and I don't count Dianne Feinstein's interpretation in the piece in the Wall Street Journal that's in the Reader as an accurate reading of the Act, I think the Act has to be interpreted to include an intent to hurt the government, hurt the United States by the disclosure, and a showing of actual harm caused by the disclosures. We'll see. Then the Jehovah's Witnesses cases and the Stevens case. The cases that we discussed there, we didn't look at all of the Jehovah's Witnesses cases that I mentioned in the chapter in the book. We looked at Lovell, the distribution, the non-licensing of the press case, distribution of leaflet. We looked at the flag salute case, West Virginia versus Barnett, which is the foundation for the rule that people cannot be compelled by government to state patriotic beliefs that they don't believe. We looked at the Woolley case, the New Hampshire license plate case, which is another instance of government-required, coerced speech, requiring you to say things that you don't believe in. And we looked at the unfortunate Chaplinsky case, the fighting words case, the case that gave birth to the fighting words exception to the First Amendment. And then we looked at the modern Stevens case, decided a couple of years ago, that dealt with depictions of cruelty to animals, and I'll come back to that in a minute. The questions are, to what extent must society tolerate speech that the majority of citizens find offensive? Well, that's what the First Amendment is all about. By definition, every First Amendment case that goes anyplace at all, anywhere near the Supreme Court, involves speech that the majority of people disavow and think should be suppressed. And if the majority had its way, if they could vote on this case, certainly the Speaker would lose. They don't want those funeral protests. They don't want depictions of animal cruelty. They want people to salute the flag and so on. The whole point of the First Amendment is to deal with dissident minority speech that the majority hates. To what extent does the right to free speech include the right not to speak? Well, we know the flag salute case is one of them. You can't be required to speak patriotic beliefs that you don't hold. The Woolley case, you can't be compelled to be a mobile billboard for the government's message with which you disagree. I guess moving to the modern era, the cigarette packaging case that we looked at on Tuesday involves an element of compelled speech. Yes, you can look at it as mere disclosure by a commercial speaker, but it's a compelled disclosure, and it's a precise message, these pictures, that the government prescribes and commands the cigarette companies to put on their packages. So I don't know about the extent to which the court may not take the case, but if it does, are they going to analyze it as a compelled speech case, or as a commercial speech case, or something else? So, you know, in the Pledge of Allegiance. Yeah, there's been litigation about that. The phrase, one nation, indivisible, under God, indivisible. The under God language, you will not find this in the Constitution. There's no Pledge of Allegiance in the Constitution. It didn't arise until the 1930s, and it was the familiar language that we have now. But in the early 50s, in the McCarthy era, another Red Scare era, we're afraid of world communism, godless communism. So the Congress voted to insert the words under God in our Pledge of Allegiance, and an atheist has challenged that unsuccessfully so far, as not as a free speech issue, but as a violation of the religious clause, the clauses of the First Amendment, the establishment of religion clause. That the government is establishing religion by requiring a recitation about the nation being under God. Has gone because God appears in all kinds of official places. That's one of them. But if you don't believe that, you don't have to say that. The government can't expel you from school because you don't even mouth the words under God. If the social value of a certain category of speech is outweighed by its social cost, can government deem the category unprotected by the First Amendment? Well, that was the government's argument in the Stevens case, that depictions of animal cruelty have so little social value. I mean, what good does it do to have pictures of animals being maimed, tortured, and killed compared to its social cost? I don't know what the government argued were the social costs of such speech. I mean, we all recoil at the idea, it's repulsive, and so on, but killing animals and torturing animals is a crime. This is a case about speech, about pictures of the killing of animals, not the killing of animals. And as we know from the Stevens decision, Chief Justice Roberts' opinion, the court declined the opportunity to create a new category of unprotected speech. Roberts recognized that the court has recognized over the decades certain categories of unprotected speech: obscenity, libel, child pornography, fraud, perjury, and so on. But the government's proposal to create a new category on the basis that its social value was outweighed by its social cost was resoundingly rejected by the court. And sounded as though that's the end of the government's attempt to create new categories of unprotected speech. But the violent video games case gave the state of California another opportunity, another bite at that apple, which the court reached that in a couple of weeks. Note also the other contribution by the Stevens decision to our First Amendment freedoms, which was the rejection of the government's argument there that the savings clause, the clause in the animal cruelty law that said speech that has artistic, political, scientific, other kinds of value are not prohibited. And the government argued, well, if there are depictions of cruelty to animals that do have social value, they'll be protected. You don't have to worry about that. And Justice Roberts properly pointed out that that turns our system upside down. It's not that we are not allowed to speak about subjects that the government blesses or disfavors. It's that we're allowed to speak whatever we want to about any subject unless there's a strong government reason for suppressing a particular kind of speech, and we engage in speech of all kinds that isn't within any kind of an exceptions list that the government prescribed. We talk about the weather, we gossip, we talk about entertainment, we talk about sports, we talk about that awful basketball game last night, and that wouldn't be protected if the government had a mind to restrict it. So where are we? Commercial speech. Geez, we're almost up to date. Commercial speech. Well, I put in the reader a couple-page description of the development of the commercial speech rules that the Supreme Court has made in decisions over the years, and you have to realize that historically there was no First Amendment protection for commercial speech, and the government could completely ban and restrict commercial speech, that is, speech that merely proposes a commercial transaction. The government can ban that at will without violating the First Amendment, no matter who the speaker is. If it's commercial speech, says, I'll sell you this horse for $25, and this horse is going to win the Kentucky Derby, that speech can be restricted. If it's false, this old nag is just about to die, it can certainly be punished and so on. Well, it has evolved, that doctrine has evolved to the point that government can regulate commercial speech that is false, even though it can't regulate political speech that is false. It can regulate commercial speech that is misleading or is about, that is, advertises illegal products or activities. But then, questions to think about: should truthful commercial speech, mostly by corporations, be entitled to full First Amendment protection? That's another normative question. Should it be protected? The fact is it isn't. That commercial speech still doesn't enjoy full First Amendment protection under the decided cases to date. I strongly suspect that there are justices on the Supreme Court, the conservative, the business-oriented, the Scalias, the Thomases, the Alitos, the Roberts, maybe Kennedy. There are certainly justices on the court that don't see why commercial speech should be treated any differently from any other kind of speech about any subject. And that corporations engaging in commercial speech should be subject to the same rules as speakers on all other subjects. So if a commercial speech were to go to the Supreme Court now, maybe the rules could be altered to give greater protection for commercial speech. But the test of whether commercial speech is protected remains the Central Hudson case test, which is an intermediate scrutiny kind of situation, not strict scrutiny for content-based regulation, but intermediate scrutiny that requires that, assuming that the speech is truthful, not false or misleading, the government can regulate it only if it shows that it has a substantial interest to be served by regulating the speech. Secondly, that the restriction directly advances the government interest. That is, this restriction works, makes a difference, actually does serve the government interest. And third, that the restriction is no more extensive than necessary to serve the government interest. And the court has put some additional flesh on that skeleton and said there has to be a reasonable fit between the ends and the means. The means used have to reasonably fit the end to be served. Last question, well, next to last question. What is commercial speech? Well, it's more than just ads. The ads are clearly commercial speech, or commercials on television and radio. Those are definitely commercial speech and subject to whatever the rules are on restricting commercial speech. But beyond conventional ads, how much speech, or what kind of speech by an economically motivated speaker, a corporation selling goods or services, will be treated as commercial speech? And the court looked at that in the Bolger case, and the California Supreme Court looked at that in the Nike case, and it's not clear.